and what's going to continue to make America really the best country in the entire world. And the laboratory for that is in our own homes, in our own communities, meaning that these rights were given to us by something that was much bigger and much greater than government, much greater than all these big things that, that the other side is pushing out, what people would call the social issues. I mean, we're talking about life, we're talking about marriage, the bedrock, because we understand, though, that strong economies are really built on strong families. And so
from Without a Crystal Ball. Welcome back to my channel. It's Friday, August 20th. We have an update because Josh Duggar's motion to compel was denied and smacked down, and then tiny parts of it were granted by the court. So since a lot of you guys are super interested in this case, and I figured we might as well talk about it, let's get into what the judge shot down and concessions that were made by Josh's attorneys regarding some allegations they made about reports and credibility issues of Special Agent Gerald Faulkner. A couple weeks ago, 2 weeks ago, Josh Duggar and his attorneys filed a motion to compel, and they were expressing that they wanted some reports related to an investigation that they claimed should exist. And they also wanted some information about a screenshot. They were obsessed with a screenshot. And then they also took aim at the credibility of Gerald Faulkner, the special agent, because they believed that testimony that he gave at the bond hearing did not match the reporting. So it was of their belief that he received a file in May, but between May and October, there was no reports. And so why? Like, they couldn't believe in this day and age that there would be no reports. After spending quite a bit of time talking about the credibility of their special agent, they also admitted they wanted some more details about a screenshot. He basically had been given, the defense had been granted a screenshot of a couple different police officers that apparently had also downloaded content from Josh's IP address, and they wanted more information from those officers and their involvement in the investigation. Now, the government clapped back and said that the officers in question did not actually provide any evidence to the government, were not a part of this investigation and working with the prosecutors on this case, and that they never actually reported this to HSI, so they didn't have any information to provide. They denied that there was a report by Detective Calmer or that they had withheld any reports from Josh Duggar and his attorneys. And in relation to the screenshot, they said that they just did not have to provide evidence because it did not fall within a specific Rule 16. So the judge had a hearing, and he was back in court on August 13th. So a week ago, they all were in court, including Josh, fighting on this specific evidence. Judge Timothy Brooks actually ruled on this case, and he outlined what he was going to be ruling on, and so it's in part denied and in part granted. So here is the information that Josh was requesting from the court. He requests the government produce the following documents related to the screenshot: information appearing under the summary and investigation tab, activity tabs that are visible in the screenshot, screenshot in the native format, the date the screenshot was captured, and the name of the individual who captured the screenshot, all law enforcement reports in the possession of Detective Calmer, the Little Rock Police Department, in connection with the investigation, and all law enforcement reports and logs in possession of the other two law enforcement officers who downloaded the same CSAM material as Detective Calmer on May 14th. So he went through the legal standards, and he talked a little bit about all the different reasons for why something should actually be granted or not granted, which I'm not going to go into because it's a lot of legalese. But he says that in regards to the screenshot, they say the first request is for information that appears under summary and investigation activity tabs that are visible in the screenshot. During the motion hearing, the government's attorneys explained that the screenshot was simply a download history of ICAC cops from a particular date. He stated that the summary tab contains information that tells law enforcement that ICAC is open, the network info such as BitTorrent, when it was last observed to be involved in law enforcement activity, and if any law enforcement has flagged files of interest. The files of interest in the tab have a 90 or 120 day look back period. The government's counsel speculated the content in this tab is likely zero at this point. With regard to the investigation activity tab, the government's counsel stated that it contains a log anybody within ICAC COPS system and will not reference those two other officers named in the screenshot unless they went and did more investigative activities. So what they did was the court says that they directed the government to review information under the summary and investigative tabs in the screenshot, and then on August 16th, their counsel from the government sent an email to the court opposing counsel verifying that each tab does not contain discoverable material pursuant to Rule 16. So they basically say that Mr. Duggar has failed to make a prima facie showing that he is entitled to information contained in the two tabs appearing in the screenshot pursuant to Rule 16. And the government's affirmative representation regarding the content in these tabs has satisfied the court that the information is not material. So he will not be getting any of the evidence from those two tabs because they say it's not material to the case. Then there was other things that they wanted. They wanted the screenshot format. So he requested that the screenshot be sent in the native format. So this is what they say. He complains that the government has only produced a picture of evidence, but not the evidence itself. But he does not disclose the original format in which the screenshot was produced, nor does he suggest the particular format he prefers. Accordingly, the request in native format is too vague to be understood and is denied. The request for the date, the time, and the name of the person who captured the screenshot is granted. So they don't understand what the native format means. They say it's too vague. He got denied. And he is allowed to know what day, time, and who took the screenshot. Now, in regards to that pesky report that they spent a ton of time talking about, basically asserting that there was no way to believe that the government in this day and age would not have any reports between months. And they claimed that because they weren't giving them reports, that it could lend to, credibility issues of Agent Faulkner. So here is the response to that. Next, Mr. Duggar requests all the Little Rock Police Department records or reports that relate to the instant investigation and that have not yet been produced to the defense. Mr. Duggar's counsel withdrew the request during the motion hearing, stating, based on the government's representation that there are not records, and we accept the fact that there's nothing for the court to compel in that capacity, the request is moot. So the government told them in their emails there were no reports. The government said, I have no reports to give you. And then they still went to the court and said, there's no reason for me to believe that there's no reports. There has to be reports. They're lying. There's no good reason why there wouldn't be reports. The government goes on official record. Now they're like, we believe you. I kind of felt like that specific sticking point was PR. You don't see it a lot, but sometimes in motions you can get your feelings out because it's an official court record. So that might have just been some feelings they needed to get out, but they withdrew that request, and that is just my opinion. So then it comes down to the reports related to law enforcement officers. So there were apparently 3 separate officers that were simultaneously downloading content from this IP at the same time on the same date in May. And the court says that they were not doing a joint investigation. So they said the government stated that the 3 police officers downloaded the same CSAM files from the same IP address within minutes of one another. But in the course of pursuing unrelated investigations, and that only Detective Calmer and not the other two officers made contact with HSI special agent to pursue federal investigations of these downloads. So 3 separate ICAC affiliates were doing undercover work. 3 of them downloaded at the same time, but the other 2 got distracted and got involved in other investigations. And so it was actually Detective Calmer that reported it to HSI. So the government's attorney stated that he directed HSI to contact the Jonesboro and Ozark police departments to inquire whether there were any written reports concerning these downloads. And the HSI officer confirmed that no reports were generated by either department. Even so, Mr. Duggar requests the court to compel the government to obtain specific information from these 2 departments related to the downloads. So the government says there's no reports, but the government did admit that the undercover law enforcement downloads were associated with a case, and with the case it utilized a program called torrential downpour, and the program was configured to search BitTorrent networks for IP addresses sharing CSAM material. So Josh believes that torrential downpour automatically generates metadata logs, which are then transmitted in some way via email or otherwise to police officers who is downloading the CSAM material from BitTorrent at the time. So for the defense, they want the auto-generated logs because they say that it might provide them evidence of what type of hardware a file was allegedly downloaded from. So it could tell them if it was an Apple computer, a PC computer, a smartphone. And they say that Detective Calmer's log had already been produced to the defense, and so they wanted the same logs for these other 2 officers since they had already received it from Calmer. So they want to verify if the metadata from the 2 people, the 2 other officers, differs on which version of torrential downpour they used, what kind of information they received as a result, whether the downloads were successful, whether there was a pathway that's reflected in there, how long it took, whether there was a disconnect and then a reconnect, whether the other 2 officers were able to actually download the file in the first place. They want information on these records to cross-reference it, I think, to hers to verify if it's matching. And if it's not matching, perhaps they can say reasonable doubt. Well, you said he has an HP, and what if it was downloaded on a Mac? That kind of thing. So the government said that they don't have auto-generated logs sent to officers in Jonesboro and Ozark, and it's not certain that logs would still exist at this point. But they said that they were not required to obtain those logs because it was unrelated to the investigation. But the court says they've been persuaded by Josh that the auto-generated emailed to the 3 different officers could disclose information to them that would either be exculpatory or inculpatory. And they also say that the government has a duty to the defendant to provide them any evidence, whether it's going to help their defense, make them incriminate, get them out of it, or even if it would to incriminate them. So they can't withhold favorable evidence just because they want to and say that it's not material. So what they want is they say that the court directs the government to accomplish this task and obtain the logs to produce to the defense. If the logs do not exist, then the government should inform the defendant of this fact. The motion is granted as this particular request. And then it says that the government is concerned during the hearing that if the court permitted Mr. Duggar to obtain the auto-generated torrential downpour logs from the other law enforcement agencies, the defense's next move might be to file a motion to compel disclosure of the source code, manuals, and software for torrential downpour. The government's concern is premature as no motion to compel is before the court. Further, the court emphasizes that its ruling today is limited to the materiality of the auto-generated torrential download logs. He has met his burden of proof in that respect. So basically, those logs are going to tell them anything. The court says he can have them And then if they don't exist, they have to tell them that. So they've already said that they don't believe they do exist. And so the government might go back to Josh and be like, dude, we don't have it. So sorry, bud. And so that one is kind of like an up in the air. We don't really know if he will get anything out of that. They withdrew the motions about the Calmer. He gets the date, time, and name of the person that took the screenshot, which I still don't know how that would be of any why that would be relevant. And they also don't get any information from the tabs. So long story short, there's no evidence from this, based on what the court shows and what the defense has also conceded, is that there is no evidence that Mr. Faulkner has any credibility issues, because he stated there was no report and there is no report. Go figure. Josh gets some tiny wins here, and then he gets a kind of a compromise. We'll check to see if these are available, and if they're not, you're out of luck. And at the end of the day, the defense wants to know whether or not police in this case all were able to get in downloads from the exact same hardware. So it's not a huge component of the case, but this motion to compel is all over. So Josh made a big to-do about nothing in regards to the reports, got a little bit of some information here, and then a bunch of denials. So when it comes to the next steps, they are afraid he might do another motion to compel, but at which time there has not been a new motion to compel that has been released. The deadline for him to file a dispositive motion to raise any defense objection or request capable of determination without trial of the general issue is due today. And then there's actually a little footnote here that says those matters are included but are not limited to defects in the institution of prosecution, defects in the indictment, suppression of evidence, and severance under Federal Criminal Procedure 14. Also included without limitation are selective vindictive prosecution, outrageous governmental misconduct, misjoinder, pre-indictment delay, speedy trial, prejudicial publicity, lack of personal jurisdiction, a bunch of other stuff. So if he wanted to do suppression of evidence, that would have been due to. So right now it looks like they are not going to potentially be suppressing any evidence, but they could file a motion in lime would be if they wanted to include evidence. So the government has up until November 3rd if they have any more evidence that they wish to include in the case. So they cannot, after today, file any motions if they want to get rid of any of this evidence. So at this point, we will see if anything else gets filed today. But for now, their motion to compel has been ordered and granted in part, denied in part, and Josh and his attorneys will move on to the next phase. They are going to have to continue with looking at the evidence and building their defense. So we'll see if there's any new objections that come up or if the government will be adding any more evidence. They still, at any time between now and the time the trial starts, they can also add charges or add things to this case at any time. So we'll see how that all goes. For now, this is all I've got. Are you surprised, not surprised? Tell me in the comments below. Bye, guys.